So in this video, we'll be dealing with the concept jurisdiction that is provided under Code of Civil Procedure. So firstly, a court cannot deal with a matter upon which it has no jurisdiction. That is as per section 9. Jurisdiction means I speak by the law, and it is also the power of the court to hear and determine a particular case. So by providing consent or engaging in a particular agreement cannot confer or take away jurisdiction of a particular court. But this is different from forum selection. Uh, by consenting or engaging in agreement to confer or take away jurisdiction is, of course, invalid. But forum selection is still valid. Forum selection is a concept where multiple courts have jurisdiction to try a particular court, and then it becomes the party's discretion to file a case in any one of such courts. And an order given by the court of incompetent jurisdiction cannot be cured by consent of parties. So if there is any defect that is relating to jurisdiction, it can be enforced at any stage, including the execution proceedings, at the stage of execution proceedings. So, and a particular court has jurisdiction, then such jurisdiction cannot be taken away or ousted by parties under no circumstances. If a court does not have jurisdiction, even though does not have jurisdiction, but it pronounces an order, it gives an order, then such orders will be invalid. Irregular jurisdiction is different from absence of jurisdiction. Irregular jurisdiction may still be considered valid, but absence of jurisdiction is a prima facie invalid jurisdiction. And any court that has absence of jurisdiction has pronounced an order, such orders will be declared invalid. But irregular jurisdiction is valid, still valid. Irregular jurisdiction can be cured via appeal or revision, but same is not in the case of absence of jurisdiction. The jurisdiction fact that the court has jurisdiction to try and decide the case, that is only upon the plaintiff to prove. The plaintiff should prove that the court has jurisdiction and it shall decide the same. It is upon the plaintiff to prove. And section 9 deals with jurisdiction. The courts have jurisdiction to try all suits of civil nature, but the courts cannot take cases where taking of its cognizance is expressly or impliedly barred. So there will be certain special laws where uh, taking of such cases are expressly barred within the ambit before the civil courts. So such cases cannot be handled by civil courts, and impliedly barred in the sense wagering contracts or cannot be enforced under the courts of law, so they are exempted. Uh, they cannot be filed as a suit before civil courts. And explanation 1 deals with what is a suit of civil nature. Suit of civil nature is a suit where it involves question of right to property or office, even though there could be question of religious rights and ceremonial questions are there. But such religious rights and ceremonial questions cannot be pure. Like the primary question should not be religious or ceremonial nature. So if a suit has right to property, but still some essence with relating to religious and ceremonial nature is there, the suit will be still considered as a suit of civil nature. So a suit, whether fees are attached to it or not, the suit is still uh, considered a suit of civil nature. That is provided under explanation 2. And what is a suit of civil nature? So, in determining if there is a question of determining civil rights as well as its enforcement, if such suit as such questions, for example, relating to property right, then that is a suit of civil nature. What are the suits that are not civil nature? Here, when the question in that particular suit is primarily of caste questions or purely religious rites or ceremonies, or expulsion from a caste. For example, if a person is expelled from a particular caste community, then such question cannot be filed as a suit in the court of law. And recovery of payment voluntarily made. So if any person has made a payment voluntarily, and recovery of such payments cannot be filed as a suit, and mere dignity or honor questions. So these are not suits of civil nature. According to Section 15, a suit shall always be instituted at the lowest grade, but the court should be competent to entertain such suits. And now we'll deal with the code of that is irregular jurisdiction. So what is irregular jurisdiction? So if a superior court takes jurisdiction of its subordinate court, then it will be considered as a irregular jurisdiction. For example, if the value, the pecuniary limit that a municipal court can entertain suits are below 1 lakh, right? So if a suit that is valued 95,000, so that suit can be tried by municipal. But subcourt, which has jurisdiction limit to try suits valued more than 1 lakh and below 10 lakh, entertains that 95 lakhs valued suit. Though it does not have jurisdiction, here it becomes irregular jurisdiction and not absence of jurisdiction, because the suit is taken by a superior court, right? So the suit valued at 50,000, I mean 95,000, but even though the suit is valued at 95,000, the subcourt still tries that suit, which has a pecuniary limit of 1 lakh to 10 lakh. In such case, it will be construed as irregular jurisdiction and not absence of jurisdiction, because the subcourt is superior court to munsif. So irregular jurisdiction is not equal to nullity according to section 99. But it is not vice versa. Like, the lower court cannot try suits beyond its pecuniary jurisdiction limit, right? And section 16 deals with suits of immovable property. So if there is any suit that is involving immovable property, then such suit can be filed within the courts of local jurisdiction where that immovable property is located. For example, in terms of recovery of immovable property, partitioning, mortgaged suits, and compensation for the wrong done. So when all these suits are relating to immovable property, then such suits shall be filed before the court that is in local jurisdiction where the property is located. Section 17 deals with when jurisdiction is vested with multiple courts of the same case, then such case shall be filed at any court of competent the court that has competency to try such suits. When there are multiple courts that has jurisdiction to hear and decide a particular matter, then at any court such suit can be filed that has competency to try. Section 18 deals with jurisdiction of a court when uncertain. Like, uh, it is it is not clear on part of the parties where to file a particular suit. So in such case, it can be filed in any relevant court, but the court that takes cognizance or takes upon that case should make a record of statement to that effect, that the case's jurisdiction is uncertain, therefore that this court is taking cognizance. So such nature of statement should be taken as a record. And section 19 deals with tort case, that to immovable property, and generally movable property jurisdiction. So when a suit involves an movable property, then such suit can be filed where this defendant usually resides or carries away his business, or where the tort is committed. So that is section 19. Section 20 deals with other kinds of suit, where the suit does not fit into any of the category, that is 16, 17, 18, and 19. Then such suits can come under the bracket of section 20. So such suits can be filed where defendant resides or where cause of action occurred. So when in case of numerous defendants are there and they have not objected with regard to the jurisdiction, and with the leave of the court, and other local non-local defendants have agreed to such suit, then in such case the court can entertain that particular suit. Section 21 deals with objection to jurisdiction. So if there is a question with regard to incompetency of jurisdiction, then it shall be taken at earliest stage as possible. That is a general rule. And in case objection has been raised in appellate or revisional jurisdiction, uh, or court, then what will be the situation? So generally, objection with regard to incompetency of jurisdiction can only be taken at the court of first instance. So when it was not taken, but it is taken, such questions are arising at the stage of appeal or revision, then the court of appellate jurisdiction can entertain. There are certain exceptions. The exceptions are such question of jurisdiction has been raised in the court of first instance itself. The court of first instance has neglected to hear that particular argument, or the such question incompetence of jurisdiction has been taken at earlier stage before the issues are settled. Along with, there will be a consequent failure of justice when such argument is not taken in the appellate or revisional jurisdiction. Only in such cases, such objections will be heard in the appellate jurisdiction courts. These rules will be applicable for execution proceedings as well. And section 21A deals with, so a court has pronounced a decree. That court does not have jurisdiction to try, but it has eventually given a decree to, so a separate suit to set aside such decree on the grounds of incompetent jurisdiction cannot be filed. Right? That is provided under section 21A, and that is about jurisdiction.